Thank you.
Prevailed over technology. Well, good afternoon, everybody, or morning, or evening, whatever the case may be. Again, I'm Mathew Meyer, and I am very happy to be here and to present on bonuses under USERRA. Here we go. So I know many of you have handled cases or inquiries regarding bonuses, perhaps not fully understanding how USERRA deals with those issues, just knowing generally what the trainers or what some commentators said about them. What I'm going to do, well, one thing, and especially long-time ombudsmen know, there are so many different types of bonuses. And there are probably as many types of bonuses as there are types of employers. And that's because oftentimes bonuses are used to incentivize certain aspects of the business, and they're tailored to incentivize perhaps profits, perhaps other things in the workplace. And employers will often tailor them to their particular business model or their business purpose. And so it's important to understand how the analysis of bonuses works under USERRA. And that's what I plan on doing today in this presentation, is sort of unlocking the mystery behind the USERRA bonuses. So in terms of the, let's see here. So today, what I'm going to do, I'm going to cover three general areas. The first part is essentially going to be how does USERRA analyze bonuses, and some of the provisions of USERRA that bear on this analysis and the determination of whether a bonus is earned, whether it's not earned, maybe it's prorated. I'm going to go through that, and then I'm going to describe generally the four categories of bonuses that I see them, and then in the second section, I'm going to discuss how, given the different types of bonuses, how do you analyze whether a bonus is to be awarded, or whether it's to be prorated, or whether the service member is just out of luck when it comes to a bonus that was given his coworkers while he was on military service. And then I'm going to have a mystery scenario. And this is going to be based on an actual case, and it's from 2014, and it really shows how to analyze a case or a scenario to determine whether or not the service member is entitled to it. So I'm open for questions. I do recommend that you use the chat feature if you can. If you do have a question, try to be brief, be succinct, and stay on point. But I believe I'm going to have plenty of time at the end of this presentation for any questions or comments or war stories that you may have about your particular experiences with bonuses under USERRA. So why don't we jump into the first part, bonuses under USERRA. Now, it would be really simple under USERRA if we could just turn to the statute or even to the regulations, and there it is, bonuses. This is how you analyze them. These are the situations where they are earned by the service member, and these are ones where they are not. Unfortunately, under the statute and under the regulations, there's only one reference to bonuses in each, and that is essentially the definition of benefits of employment or benefits. So if you are prone to go to the regulations or especially the preamble, the preamble has many references to bonuses, but for the most part, you're looking for benefits because a bonus is a benefit. And the way that USERRA treats it, that's not the end of the analysis. Bonus is a benefit, but there are two types of benefits. If you're familiar with USERRA and especially the paid leave of absence provisions, If you're familiar with the accrual of vacation time, so on and so forth, you've heard the distinction between seniority and non-seniority benefits, and that's what drives the analysis under the bonus provisions under USERRA. So where do we turn to initially in looking at this? We turn to the regulation 212 and the definition of seniority under section 4303.12. Now, essentially, a seniority-based right or benefit is one that accrues with or is determined by the longevity in employment. That's a key provision. That defines the seniority provision, right? So if it's a seniority benefit, it accrues with the longevity in employment. Now, if you move to the regulation under subsection A, it provides a little more context to this definition. So whether a right or benefit is a reward for length of service rather than a form of short-term compensation for work performed. So that creates the distinction between seniority and non-seniority benefits. If it is a reward for the length of service, it is a seniority-based benefit. If it is a short-term compensation for work performed, it is a non-seniority benefit. And that is the distinction that is going to drive our analysis here. If it's a reward for length of service, it's basically a longevity bonus. And if it is a form of compensation, that's where we get the distinction that it is not earned during a military leave of absence, because under a military leave of absence, the service member generally is not entitled to non-seniority benefits because they are a form of compensation and the service member is not working. Of course, many of you know that there are exceptions to that, and we're going to discuss some of those. One other part of this that is that you may want to be aware of is the provision where the actual customer practice determines whether the benefit is a reward for length of service. In other words, the policies and procedures, the employee handbook or whatever, it may have verbiage in there saying, hey, this is for short-term compensation. This is for performance, or this is for whatever. If the actual practice of the employer is different than that or suggests otherwise, then the practice will prevail. And that's an important distinction that comes up frequently, especially with smaller employers. If you're dealing with a small employer and there's like one owner, CEO, president, and he just decides arbitrarily and subjectively, I'm going to give a bonus this year, and I'm going to include Joe. Joe only began a few months ago. It only worked a few months, but I really like him, but so I'm going to give it to him. Well, that is a policy or practice that may vary from what the written policy is. But if another employee was gone on military leave of absence for say 9 months, then they would be entitled to that bonus as well, because the owner made a distinction. In practice, he deviated from what his policy was, and he created a practice where that bonus would be earned even though you did not work the entire year. So that's an important provision there. Another provision that bears on the bonus analysis is 4316A. Basically, it discusses the seniority-based benefits, how they continue to accrue during a military leave of absence, but they're not earned until the service member is actually employed. So, let's say there is some longevity bonus that's awarded and the service member would like that while he's out on deployment, he or she does not earn that or is not entitled to that until they return and are reemployed by the employer. Another provision that we're going to discuss is the escalator principle. And we've all heard of the escalator principle in terms of the reemployment process, determining what the reemployment position is, and so on and so forth. And if you look in the definition of that, it's not only the position that reflects with reasonable certainty the pay, seniority, and other job perks, but the benefits. And if you recall what I said at the beginning, bonuses are included in the definition of benefits. And in a few slides, I will get to longevity bonuses and how this will be impacted. But just keep in mind, when you're determining what, if any, bonus the service member is entitled to, it should reflect the escalator principle, the whatever increase in pay, seniority, whatever that the service member is entitled to. So another provision, and I'm sure many of you are familiar with this as well, the most favorable leave of absence section. And I'm sure a lot of you follow USERRA cases when they come up in the news, and you may have heard of many class action lawsuits where employees or service members are claiming that they're entitled to paid leave because the employer offers comparable leaves of absence that are paid. And oftentimes they compare the short-term, like annual training or short, service that they need to do to paid jury duty or paid bereavement leave or whatever. That is a benefit, and that same analysis applies to bonuses. So if the employer's policy says, well, we don't provide this bonus because it is a performance bonus. We don't provide this bonus to service members on a military leave of absence, but we do provide it if you're gone for an extended bereavement leave or maternity leave or some other type of leave. That would fall under the most favorable leave of absence policy under the sections referenced there. And the service member would be entitled to the most favorable leave of absence policy offered by the employer. Ergo, the service member would probably be entitled to that bonus as long as it was comparable to the military leave of absence that he or she was on. And then finally, we don't want to lose sight of the anti-discrimination provisions under 4311. Essentially, 4311 is probably the most succinct and shortest section under USERRA, but has the largest impact, especially in terms of number of cases handled by ESGR and number of complaints submitted. Basically, an employer cannot deny any benefit of employment on the basis of the employee's membership, past, present, or future membership in the uniformed services. And it doesn't have to be overt. It doesn't even have to be a conscious decision to discriminate. If the policy is set up such that a service member is disadvantaged because of some requirement. For instance, let's say in order to qualify for a bonus, the employee has to be actively employed and on the roster the first and last day of the year. Well, what if he was called to uniform service during one or both of those periods? Can he be disqualified? No. That would be a disqualification based on his uniform service. And it may be affected by other aspects of uniform service. For instance, the employee must be on call, certain weekends, and it conflicts with the weekend drill of the service member. There are all kinds of aspects to bonus programs set up by employers. And like I said at the beginning, they're very varied in what their requirements are, or the obligations of the employee in order to qualify for them. So these are all going to bear on our analysis of the types of bonuses. So here and this is my sort of categorization. I've described 4 categories of bonuses. And the first is the non-seniority based bonus. This, like I said before, is a form of compensation. And actually, I should qualify that. It's a form of short-term compensation. When I get to our mystery scenario, it's based on a case where it goes through with a lot of analysis. And one of the distinctions was, that any kind of bonus can be construed as a form of compensation. Or most can, I guess, longevity bonuses, but it's a form of short-term compensation. In other words, compensation of active participation in the workplace and in the productivity of the company during the particular period of time, not compensation for a lengthy and wonderful career working for this particular company. And so the non-seniority based bonuses are a form of compensation, and you'll often see them referred to as performance bonuses, productivity bonuses, and you'll often see them calculated based upon some metrics related to the productivity of the company. For instance, in the legal profession, it might be the number of billable hours. In the manufacturing sector, it might be the number of widgets made during the particular bonus period, or in the retail sales area, a number of sales made of widgets. So there'll oftentimes be a particular criteria directly related to the performance during the bonus period. Another thing to keep in mind, I'll just throw that in here, but it relates to all of these. Always be attentive to what is the bonus period. Sometimes the bonus period is the calendar year. If a company is on a different fiscal year, it would be on the company's fiscal year. Sometimes it'll be quarterly. The quarterly performance, when the numbers come out, then a bonus is earned. So always be careful of, what is the bonus period and how does it relate to the service member and the service member's leave of absence. The next type of bonus is the seniority based, and I've alluded to this a few times, but essentially it's just a reward for remaining employed by the employer. You're seeing these more and more. As a matter of fact, here in the Twin Cities, just within, I believe, the last year and a half, the Minneapolis Police Department instituted a peer longevity bonus because of the high turnover since the rioting and the George Floyd riots. And the inability to recruit, and you'll see longevity bonuses oftentimes in the public sector, for instance, the police department, and they're designed in order to increase retention or decrease turnover in the workforce, because the municipalities are focused on having first responders. They're not, they don't have a profit motive. They're not worried about revenues or profits or anything alike. They're focused on having sufficient first responders. So those are longevity bonuses. And don't get me wrong, longevity bonuses can be in the private sector as well. Some businesses may have a combination of longevity bonuses and performance bonuses. And therefore you want to always be aware of, does this look like a longevity bonus, or is this a performance productivity bonus? I would say, and this is just based on my own experience, but non-seniority bonuses, probably about 90% of the bonuses are in the private sector. Or I should say, of the private sector, is productivity bonuses, because they are looking at the bottom line, whereas seniority-based bonuses, longevity bonuses, are oftentimes in the public sector. And then there are a couple of other categories here that are worth mentioning. Absence of occurrence bonuses. These are often to reward safe workplace maintenance, safety in the workplace. In other words, if you as a worker has an accident, or your unit or your group has an accident, and that would disqualify you from a bonus. Obviously, you want to look at what does it incentivize, and in this case, it incentivizes the employee not to do something, not to act carelessly, or defy safety protocols or regulations, or tardiness, not to be tardy or late to work. That would disrupt the workforce. It's not a form of compensation, because they're not otherwise being paid to be safe. They're not otherwise being paid to not be late, and therefore it's oftentimes would be a non-seniority, or a seniority-based bonus, but it can be a non-seniority based. For instance, performance. If you're absent, a certain amount of time in a particular period, that could look more like a non-seniority based bonus. So you have to go through the analysis and understand, does this look more like a seniority based bonus or a form of short-term compensation? And then there is sort of a hodgepodge category of other. And I just threw these together. Sometimes they're true bonuses, sometimes they're just called bonuses. They don't really fit well within one of the other categories, but they are bonuses. Severance bonuses. For instance, there was actually a Supreme Court case pre-USERRA, but it's still followed, that specifically said severance bonuses are a seniority-based benefit, because it's not a form of compensation for your whole career working for the company that you're being discharged from. It is because of the longevity of your service, and as a benefit because you're no longer going to be employed. Signing bonuses. I will get to this in a couple of slides, but sometimes there might be special circumstances where, especially in collective bargaining agreements, the union members may be entitled to a signing bonus once the collective bargaining agreement is entered into. That too would not be a non-seniority based bonus, because it's not a form of short-term compensation. So it would be the service member would be entitled to it, even even if they were gone when it was awarded to everybody. So the second section I'm going to deal with is, given these different categories, well, how do you analyze them? How do you determine what bonuses they're entitled to and how much? And if you look at the right-hand side of the screen, now these are the options for each of the categories. Is the service member, or under what circumstances would the service member be entitled to the full bonus? Or would they be entitled to a partial bonus? And when I say partial, I'm typically talking about a prorated to reflect the amount of time that they were actually working during the bonus period. And then, sometimes there's just no bonus. And I think oftentimes when dealing with productivity bonuses or whatever, that is a very definite option if they were gone for the whole year. So with productivity or performance bonuses, like I said, they are a form of compensation, and they're typically not earned during military leaves of absence. But like I said before, if there is a more favorable leave of absence policy for a comparable leave of absence, then that service member may be entitled to the bonus, either the full bonus or the bonus that the comparable leave of absence policy dictates. So you want to ask, when you're working a case, you want to ask, okay, well, what other types of leaves of absence are there? And beyond what the employee handbook says, how does management award these? Are they following the policy, or are they just saying, well, we like this person, so even though they've only worked part of the year, we're going to give them the bonus nevertheless? Then, if there isn't a more favorable leave of absence policy, and I'm sure a lot of you have gone through this exercise before, the service member, if they work part of the bonus period, and the classic example is they worked 6 out of 12 months, right? And then they left, and they come back, and oftentimes with productivity bonuses, they'll have like a threshold, that they have to work a certain number of hours or make a certain number of widgets in order to participate in the bonus. Now, the returning service member, if they can show with reasonable certainty that they would have participated in the bonus had they remained continuously employed, and that would basically involve extrapolating, whatever their rate of work was during the period that they worked to the period that they were gone. And if they would have qualified, then the bonus that they would have received would be prorated to reflect the actual period of time during the bonus period that they worked. In my example, it would be 6 months, basically 50%. So they would have 50% of the bonus they would have earned had they remained continuously employed. They cannot be divested or can't forfeit their right to the bonus for the period that they actually worked, because again, it's a form of compensation and it's a non-seniority benefit that they have already earned. And then finally, if the service member didn't work at all during the bonus period, let's say they were gone for a multi-year period, they're just not going to be entitled to the bonus, and it's really doubtful that the employer would have any kind of comparable leave of absence policy that would grant a bonus under those circumstances. Longevity bonuses. Again, these are usually designed to reduce turnover and increase retention. That's what they incentivize. And the question, pretty much the only question, is would the service member have received the bonus had he remained continuously employed? As the court in the case upon which the scenario is based, basically said, well, that's the easy question, in the analysis. The harder question is whether it's a whether it's a seniority-based bonus or a non-seniority-based bonus. So we'll get into that scenario and some of the clues in that analysis. But if it is a longevity bonus, the service member is entitled to the entire bonus once they return. Even though they were gone, they may have been gone for the entire bonus period. Let's say they had extended orders, and when they come back, they would be entitled to the longevity bonuses for the bonus periods that they missed. And once it is determined that it is a seniority-based bonus, the employer cannot prorate it. If it's a seniority-based bonus, you earn it just by being employed, and the statute says that you're considered employed on a military leave of absence status during your absence, and therefore you've earned the seniority-based bonus, period. So Looking at the longevity bonuses, generally they wouldn't be prorated, so it wouldn't be partial. And the only reason you would not receive the bonus is if you chose not to go back to that employer or you did not have USERRA rights. That would basically be the only way you would not have that bonus. Otherwise, the employer would have to pay the full bonus once you return to employment. Absence of occurrence bonuses. Like I said, these are sort of unique. Sometimes it could be a non-seniority benefit. Oftentimes they are a seniority benefit because it's not a form of compensation. The one thing I would say about this is the employer cannot say, well, you know what, this bonus is that you would be safe for the whole year. And yeah, granted, you didn't have any incidents the first 6 months that you worked here, but you might have had an accident the second 6 months when you were gone on military leave of absence. An employer cannot assume that the service member would be disqualified. And so that would be improper, and the service member would be entitled to it. However, if in the period during the bonus period there was an accident, if the service member did have an accident that would have disqualified them, then they would not be entitled to that bonus, even though they were gone for the second half of the year. So moving on to holiday pay, signing bonus, and severance bonuses. They're really fact specific in terms of how they're treated. But some things to look for in analyzing these types of bonuses. For one, I did say severance bonuses and signing bonuses are essentially a seniority-based benefit or bonus. But oftentimes these types of bonuses will have all kinds of exceptions. If you were gone for maternity leave or on union duty or bereavement leave or whatever, then that doesn't count towards your absenteeism or whatever. And if that's the case, then it's a easy analysis. Essentially, the service member is entitled to the most favorable leave of absence policy for a comparable leave of absence. And so if they were gone on a short-term military leave and it's comparable to bereavement or jury duty leave, and that's exempted, then the service member is entitled to it. Again, the discrimination provision, like I mentioned earlier, if there's some requirement to one of these bonuses and it runs headlong into the employee's military service obligations, the service member should not face forfeiture of the bonus simply because he was on uniform service at that time. As I mentioned earlier, the escalator principle, and this is an interesting case that I cited here. It's Human versus FedEx, and it involved the signing bonus negotiated by the airline pilots union for FedEx. And it was negotiated and entered into while the service member was on uniform service. And with these types of signing bonuses, they will have a particular date that determines who is or is not eligible for whatever signing bonus. Well, this particular signing bonus, it had a lower rate for pilots of regular jets, but the wide body jets, the bonus for those pilots was $10,000 more. And what happened is that the service member showed with reasonable certainty that the escalator position that he's entitled to would have been as a pilot of the wide body jets, even though at the time that the bonus was established, he was the other kind of pilot. But he said, well, if I had remained continuously employed, I would have gone through the training, the qualification, certification, licensure of a wide-bodied pilot, and actually did. And with the escalator principle plus the retroactivity of the escalator position, he showed that as of the date when the bonus was determined, he would have been a wide-bodied jet pilot. And so by application of the escalator principle and the retroactivity concept, he was entitled to that bonus. So always pay attention to those concepts and how they may affect your analysis. So here is the mystery scenario, and it's based on the case. I actually cited it there. And it involves a tech sergeant, DeLee, in the Air Force Reserves. Now, he started with his employer in 1997. Or, excuse me, he started in the Air Force Reserves in 1997. And then a couple of years later, on April 11, 1999, he was hired by his civilian employer. And 12 years later, he ended up going on an extended deployment. So he ends up returning to work after a 9-month deployment on May 11, 2011. Now, the employer had a policy, a bonus policy every year where the employee would receive a certain amount, and DeLee would have been entitled to $2,700 for the year had he not been deployed. However, the employer prorated the bonus and said, well, you only worked for the first 4 months out of the year, and you didn't work for the last 8 months. So we're only going to give you $900 for the 4 months you worked prior to your deployment. And he did not receive the $1,800 for the 8 months he was deployed. He was on deployment. So, we have a bonus. We have it prorated. It seems like it's accurately prorated. Given the amount of months that he worked and the number of months that he was on deployment. So is the case closed? Obviously not, because it wouldn't be much of an example. And so what I'm going to do is to solicit your opinions. Now, I have a series of boxes. There are 8, 2 on this page and 2 on the other page. And let's see here. And I need to get rid of this here. Well, now that's not working. Okay, so the question is, given the scenario that I described, what are some of the clues or factors or issues that you would want to explore in order to determine whether this is a seniority-based or a non-seniority-based bonus? So does anybody have any thoughts on that? Has somebody had a longevity bonus case or a seniority-based bonus case? And what were some of the factors involved with that case?
We've got some questions in the chat. We've got, would he have received the bonus if he had not been off on military leave? From Christy Nixon. She suggests that if yes, he gets the full bonus. We've got Mr. Lilly asking, what were the conditions of the bonus? I think that's a reasonable question. And Mr. Troike from Oregon asking, did the employer request to leave, or did the employee request to leave for service, or was he required? So an interesting series of questions and statements in the comments, but we'd be happy to hear from anybody who has some other thoughts. If you'd like to raise your hand, take yourself off mute, you can join the conversation.
Okay, well, I tell you what, first, I want to, I'll give everybody the first two. And these are sort of standard when working any kind of an ombudsman case. The first question is, does the service member meet the 5 eligibility requirements? And in this case, yes. And an ombudsman should always confirm that when working a case. And then second is, do other employees on comparable leaves of absence receive the full bonus? No, they did not. Now, the questions, Tara, the one was whether he was volunteered or if it was involuntary.
Yep, it looks like there might be an involuntary versus involuntary service question. And Mr. Troike, if you'd like to expand on that, you're welcome to. But it looks like it was a voluntary versus involuntary.
And then Christie's question was about,
would he have received the bonus if he had not been off on military leave? So how would he have been treated if he had been continuously employed? And then we have some questions about policy and practice at the workplace.
Yeah, I could expound on that because I worked for the DEA and federal services for years, but I was a reservist. And a lot of times an opportunity came up to earn some extra money for reserves to benefit your reserve program, but it wasn't really required of me. So I feel sort of guilty taking a bonus when I chose the latter. So I don't know. That's an interesting question.
Well, and keep in mind what we're doing is to explore whether this is a seniority-based or a non-seniority-based bonus, and the service member claims it's a longevity bonus. The employer is saying, hey, it's a form of compensation, and as proof of that, we have this policy where we actually prorate it to reflect the amount of time that you're actually working for. So in answer to Christie's question, in the scenario, had he not been deployed, DeLee would have received a $2,700 bonus for the year. So yes, he would have received it. But that doesn't necessarily get to whether it's a non-seniority or a seniority-based bonus. If it was a non-seniority-based bonus, a productivity bonus, he would have also received it had he remained continuously employed. So what are some of the factors? And Mr. Troike, you were in the federal government, right? So did they have a longevity bonus that they would give?
Well, I don't think. Well, yeah, there was time and grade. If you're 1 to 3 years, you got so much, and then if you were longer than 3 years, the step increases. But generally, there were no bonuses paid in that respect, but there was some performance-based bonuses, but not longevity bonuses.
I wanted to go back to this slide because there's a clue on here, in the typical Columbo fashion. What are the clues that we're looking for? And there's a clue on this page.
Mr. Wheeler has his hand up.
Mr. Court.
Mr. Wheeler, we've got you on mute.
So there, now I'm in. One of the things you might also want to look at to simplify this, in dealing with the employer is, what does for instance, in a police department, what does the employer do for bonuses for the people who are out on workers' compensation or out for medical leave, et cetera? If those people are getting the bonus, they're certainly not performing any work. Okay, so that would simply take it out of this is based upon work that you do. Okay.
And that would be the comparable leaves of absence. If always compare it to other types of leaves of absence. But it's interesting, Court, that you brought that up, because in the case, the court actually went through and it highlighted how there were these exemptions. And there were exemptions for sick leave and other types of leave. And
Good afternoon.
It wasn't because of a more favorable leave of absence analysis, but it was part of the analysis of whether it was compensation for time worked. And the court said, well, you don't get more if you work extra hours, and you don't get less if you work, the minimum number of days because of the sick days and the scheduling or whatever. In other words, it doesn't fluctuate by the number of hours worked. So I would put that under this 3. How are the bonuses calculated? And the overall concept behind this is that the bonuses are calculated based on the number of years of service up to a max. It's not. It doesn't look like compensation for time worked. It looks like compensation for longevity of employment. And one thing that the court specifically observed or analyzed was, this amount didn't fluctuate. If it was a busy time of year, if there's a lot of overtime, or if there was little time or time off or sick leave or whatever. So look at how the bonuses are calculated as a good clue as to whether it's longevity or productivity. Robert.
So, taking your hint, I saw that it was marked on the calendar, which is something that a lot of us, if we're expecting a bonus, and then all of a sudden some military service comes in between, that date, between now and that date, it would appear that there may be this may be a seniority based, since it's something that was generally expected after a passage of time. And so with that, the questions of, is it a mere passage of time, or is there some productivity level or standard that has to be met? So that gets to those two questions, the productivity versus a mere passage of time.
Well, and that's a very good point, and it sort of goes into how bonuses are calculated as well, because it's just a flat rate for every year, regardless of the fluctuations. Whereas a productivity bonus would be calculated based on whatever the revenues or numbers, whatever metrics are used for that year. The April 11, if you remember from the scenario, was his employment date. And that's when the bonuses are awarded.
Yeah.
And if you look at the scenario, and there was another clue in there as well, because he was gone for 9 months, but the bonus period included 4 months before he went on and 8 months of his 9-month service. And that's because he came back 1 month after his anniversary date. So he's into the next bonus period, 1 month into it, and he's looking back at the bonus that should have been awarded on his anniversary date per the policies of that employer. And so one thing that you'll see with these longevity bonuses is that they'll often be on the anniversary date. And it doesn't make sense for a productivity bonus to be on an anniversary date, because the employer, a private employer, is always looking at, well, what was the production, the year end, the overall year production, or the profits or the revenues or whatever the metrics are. Only in cases of longevity would you have an anniversary date as the date a bonus would be awarded. And actually, in terms of the Minneapolis Police Department, they use the anniversary date as well. Now, it's not necessary. You know, they can, oftentimes they may adjust it so that they're giving the bonuses out to everybody at the same time. But then what they'll do is adjust people's accrual of that bonus so that it switches to a particular date. But if there is an anniversary date used as the accrual date, more than likely it's going to be a longevity bonus.
Yeah.
So let's see here.
Matt, Court, I was also going to note that the employer, the city's trying to say, well, we give a prorated bonus to people who started later in the year. They couldn't give a bonus to somebody who wasn't employed for a period of time. So it doesn't automatically follow that because Johnny got, a bonus based upon 3 months of employment because he had just started, that meant the whole program was based on productivity. So I understand their argument, probably the best one they could have made, but it doesn't necessarily follow through because they couldn't have given him a bonus when he wasn't employed.
Correct.
Whether it was longevity or productivity.
And that was an important point that you brought up the other day, and I think that goes to sort of the more favorable leave of absence policy, and quite frankly, like I said, a lot of these smaller companies where the owner is really subjective on the amount of the bonus and who they give it to, they really run the risk of undermining it as a non-seniority based benefit if they don't have strict policies that they actually follow. Another thing, and the question is, well, what does this incentivize? Does it incentivize productivity?
No.
That's number 5. And the ordinance in this case actually said that the employer is long recognized as an incentive for police and firemen to remain in the service of the city. So the stated policy was retaining rather than a form of short-term compensation. So that gives us another clue as to another big factor. And I mentioned this when I was talking about longevity bonuses. And that is, what type of employer is this, right? Basically, is it a public or a private employer? And you may have seen from the citation, it's the city of Plymouth in Indiana. And again, public employers are more often to have longevity bonuses than private employers. So look at that, because they want to reduce turnover. They want to keep the experience, especially first responders, in their employ. And private employers are just interested in the bottom line and the profitability or productivity for the year. And then let's see here. Oh, wait. Yeah, I did not mean to do that. Now, another thing that it was actually cited by the court when analyzing this is, when does the service member qualify for the bonus? In other words, in this particular example, there was the employee did not qualify for that bonus until they had been employed for 3 years. And if it's a productivity bonus, you're not worried about whether they've been employed for that long. They're still contributing to productivity. if it's a longevity bonus, then that would be a concern to you, because you're not as interested in keeping a rookie on the payroll as you are an experienced first responder or fireman or whatever. And so oftentimes with the longevity bonuses, they won't kick in or accrue until you've been in the employ for a certain amount of time. And that was actually a factor used in the court in analyzing this. And then finally, the last factor, what if the employer changes the policy to prorate the bonus? And this too, the court really looked at closely, because the city actually prorated this pursuant to the ordinance saying we want to prorate this bonus, and the court looked behind that policy and basically said, well, okay, it wasn't a productivity or profitability motive or a compensation motive behind it. It was simply because of budgetary reasons. They wanted to reduce the amount that this policy was costing them. And so it basically said, well, we don't care, what they characterize it, or if they prorate it as a productivity bonus. If it is a seniority-based bonus, they cannot prorate it. The employee earns it by the longevity, and we're not going to use that necessarily to conclude that it's a non-seniority benefit, because it was clearly motivated by them reducing the budget, as opposed to a compensation or short-term compensation for work performed by the employee. And so much of the analysis went to looking at the real core basis or reason for the policy, and whether it was really for productivity or performance, or was it longevity. And as the court actually examined, sometimes employers will try to employers or collective bargaining agreements or whatever will try to hide the true nature of whether it's a seniority-based bonus as opposed to a non-seniority-based bonus. And it doesn't really matter how they characterize it. It really matters whether it is legitimately a form of short-term compensation for work performed. And that is sort of the penultimate question that is asked to look at, to analyze whether it is a longevity versus a productivity bonus. And I guess we've solved it, hopefully. But any other questions? I had expected to have more time for questions or war stories or whatever, but are there any other comments or questions about this?
We've got a couple of questions that are coming through, but I do just want to state that if anybody needs to jump off, we want to respect your time. Game plan was for an hour, but this is going to net a lot of interesting conversation. So we'll keep the recording going as long as there are pertinent questions related to the situation. Do you want to remind anybody who is jumping off? Again, we've got sessions for next month scheduled for the 8th, the 9th, and the 11th. So thank you so much for joining us today, and we'll see you next month. But we'll continue with any questions. I do also want to state that we had some really great participation in the chat. So thanks all for joining us there. A lot of the comments that Mr. Meyer eventually made about how to establish a determination of the situation were mentioned in the chat. So nice work in dissecting this case. But we'll get to some questions for you. Mr. Castillo, I see you first.
Yes, ma'am. I had a question. Can you hear me?
Yes, sir.
Okay. I am an area chair and I do a lot of unit briefings, and we always mention bonuses. And after listening to this today, it's very complicated. It sounds very complicated and very in depth. what is the best way? Just say if you're looking at maybe possibly getting a bonus, or you did get a bonus, your company did give bonuses while you were away, you need to contact an ombudsman first and foremost, or not even mention bonuses.
Oh, by all means, mention bonuses, and I would even go as far as to say, a lot of bonuses, at least for private employers, are not earned, but there are some factors that would require an employer to pay them, whether they're a form of compensation, or especially for longevity bonuses, and then direct them either to Ombudsman or the national call center. Everybody there is just great at these types of issues, and they could walk them through that to determine.
And the other thing is that I do a few lunch and learns with Chamber of Commerce's in my area in Texas. That is also one of the things that I cover is bonuses. So again, to the employers, would you say to contact the 1-800 number and ask before you for your service members, or what?
Well, obviously the call center is open to employers as well, and I'm sure that they are more than happy. One thing to keep in mind, though, and I represent a lot of employers, and sometimes these things get sort of nuanced, and there are a lot of gray areas, as suggested by the Lee case. Not only the employer had it wrong, but also the district court judge, because the district court judge found the opposite as the federal circuit court. So, going through these types of issues can be sort of complicated, and the call center will give sort of a brief answer, but they really need to consult with their employment law attorney, as to how these bonuses, should be structured, one way or the other in terms of service members on a military leave of absence, because there are a lot of pitfalls, or a lot of issues there that really can't be covered completely by the National Call Center.
Thank you. This was
Mr.
very
Meyer,
good training.
There is one request to slide back one slide. I think folks liked the options 3 through 8 to consider. And we did also have the suggestion in the chat as well that there are resources available at the Department of Labor, Veterans Employment and Training Service for employers and employees who have specific questions about their bonus circumstances. So don't forget that as a resource too. All right, Mr. Manion, you're next.
Thank you, Tara. Matthew, how did the Supreme Court decide the case? I think we know, but I'd just like to hear it.
Oh, actually, it did not go to the Supreme Court. I'm sure it was probably settled or resolved at the Seventh Circuit level. But the opinion is very very good. It relies a lot on prior Supreme Court decisions, and I say prior, I mean prior to USERRA. But of course, those are still used for guidance in how to interpret USERRA, and there was one involving a severance bonus, another bonus issue under a collective bargaining agreement. So there was some good analysis in there, and it really looked closely at what the true purpose of the bonus was, notwithstanding how the employer characterized it or structured it or referred to it.
So how did it wind up?
The Seventh Circuit reversed the district court and found that it was a longevity or a seniority-based bonus, and that the delay was entitled to the full bonus.
Thanks. Good presentation.
Thank
Mr.
you.
Pitts.
Thank you. Mr. Castillo, are you still you still have a question?
No, sir. I was just, I was still listening. Thank you very much. It was good help, very helpful information. I guess.
Thanks,
Oh,
Mr.
Mr.
Castillo.
Pitts.
Yes. Hello.
Yeah, I'm here.
No.
Mute your thing over at with the training. But no, court gets into the weeds so damn much. The damn brush hog can't cut the weeds. You there?
Yes.
Okay. So they get real complicated. I quit listening 30 minutes ago. It got in over my head. If I'm getting into that deeper stuff, I'm calling the DOL people and saying, "Hey, help me out."
Yeah. I mean,
Well,
That might be a good suggestion.
Oh, just a second, Mr. Pitts. I just want to comment on George's comment. You know, a lot of this isn't designed for you to, conclusively, decide, whether or not they're entitled to it. The main thing to take away from this is to understand the nuances involved, and there's going to be some uncertainty there. And as an ombudsman, I think it appropriate to express that uncertainty to both the service member and the employer. But if you are able to at least understand where the ambiguity or the uncertainty is, you can alert them to it, and that there may be an issue, and it may be best to resolve it. Rather than to contest it. And then, the service members, oftentimes we are the first people to interact with the service member. And if we basically say, well, you're not entitled to that bonus, period, they may not be encouraged to follow up. Whereas if we said, well, this is sort of a complicated area, you may or may not be entitled to it. I don't feel completely competent to tell you one way or the other, but there may be an issue here, and here is the DOL vet's contact information, and they will take it one step further and decide on their own. But if we don't offer them that guidance and express to them that uncertainty that they may have a basis for an issue, they may just leave it at that. Mr. Pitts, you had a question?
Yes, just when you thought you knew all the answers. I'm also an area chair in Maryland, and always during the briefings, I go over bonuses. If everybody else gets a bonus, you get a bonus. Is that still a fair way of presenting it? With the caveat, there's always exceptions to the rule.
Well, when you say if everybody else who is either employed or
in your section,
if others on a leave of absence that are comparable are receiving it, then yeah, they should receive it.
You're deployed in your section that you're part of. Everybody gets the bonus.
Well, you mean the others who remain employed while the service member employee is gone, but the others remain and they get a bonus?
Yes.
Oh, well, the question is going to be, is it a seniority-based bonus or a non-seniority-based bonus? If it's a non-seniority, usually if it's a private company, you have a section working on widgets in the back room, and they as a team, work together and either earn or don't earn that bonus. Usually it would be a non-seniority based bonus. It would be a form of short-term compensation. One thing to keep in mind, I sort of considered this. I've never ran into it with my own clients, but with these large government contractors, they may have projects that go on for years and then a bonus at the end of the project. And so the bonus period could stretch out over a number of years while the super weapon that they're developing is being developed. And if that's the case, that there's like this big bonus at the end, that would typically be a form of compensation. And then you'd have to look at, well, who all is participating in that bonus, and are they participating based on the amount of time that they worked on it, or were they just there at the end and they received it, in which case everybody who worked on that might receive it. It can be a little complicated in those situations, but penultimately the question is it a form of short-term compensation? And if it is a form of short-term compensation, they would prorate it to the period that they actually worked during the bonus period, or they would be entitled to it, if there was more favorable leave of absence policy that also participated in it. But it's probably somewhat misleading to say, well, if one person gets it, everybody gets it, because if it is a form of compensation, then you have to ask some more questions about it.
Yeah, I'm just looking for, as a briefer, a safe way of presenting that.
What I would do, and I give many briefings, and what I do is, bonuses are covered by USERRA, and typically they're a form of short-term compensation, and the service member wouldn't necessarily earn it, but there are circumstances where they may, and there are other longevity type bonuses that you would be entitled to. And if you have particular questions, talk to an ombudsman or call the national call center to get more details on that.
Thank you.
Mr. Kimball piggybacks on the chat of anytime we use unit briefs and say things like, "It's like you never left," is probably a good idea to not state during briefings, because it's not always true with all of the nuances of different situations. So great comment there too. We've got a lot of comments about the slide deck. After Mr. Meyer makes his final presentation on Saturday, we'll collect his final slide deck from him, and we will post it on the MMS documents library under Ombudsman and Ombudsman Sustainment Training. There's a lot of interest in sharing this good information with other volunteers, both outreach and Ombudsman. So thanks, Mr. Meyer, for putting together this excellent presentation. So thank you. We've got a couple of comments about how we're going to get credit for this training. Just like we have in the past, we've collected a list of participants, and the team at headquarters will ensure that your participation is noted in your MMS profile under training, and you'll receive credit for the volunteer hours that you've spent with us today. Providing good briefs that don't put service members to sleep is part of the challenge as providing volunteers. Tend to agree, Ms. Trout. I trust that you can do that. Great. Are there any other questions? All right. Well, seeing none, I want to extend my thanks again to Mr. Meyer for this wonderful information and this comprehensive presentation. Your time and energy here is greatly appreciated. And also to all of our participants. The participation certainly makes these programs even more interesting. So thank you for spending your time with us this afternoon. We will look forward to seeing you next month. And again, if you are not currently an ESGR volunteer ombudsman, would like to consider taking on that role in your volunteer time, talk to your ombudsman director in your state or reach out to your volunteer support technician, because those 2 volunteer training opportunities are coming up this year, and we'd love to have you join the team. Thank you so much to everybody who is here. We'll stay on the line until everybody's gone, but thank you for being here.
Thank you, Tara.
Great job, Matt.
Thank you.
Thank you.
Very well done. That is so interesting. My team is over here on the team chat, Mr. Meyer, commenting like, "This is great. Where can we find these slides? We want all of this." I had the call center team join these Wednesday sessions, and everybody was very excited for this particular presentation because bonuses are just so they're just so nuanced. And so having the words and the tools to be able to explain it clearly is so valuable. So thank you so much.
Well, could you imagine I could get through an entire hour just talking about bonuses?
Oh yeah. Thanks, Matt.
Oh, thank you.
Good stuff.
Great presentation. I'm not planning to go on as an ombudsman, but I'm sure there'll be questions that are fired down the road somewhere. So it's been very variable. I'm going to try and tune into as many of these just to get up to speed on what's out there and how you react.
Well, and that's what I think is so great about the way we've evolved this year and opening it up to non-ombudsman, because it increases the quality of our briefings and our interactions with service members and employers the more we get this information out. So what was the total for the session, Tara?
We went up to 83 at one point.
Excellent. And